This conference is not only unusual, perhaps unique, because we're actually having more than one discipline and disciplinary language and approaches speaking. It's not unique because it goes on for too long and we have lots of interesting perspectives. But we've also decided to end... We're going to end the next hour and a half with a roundtable of relatively short, introductory statements, and then discussion among the panelists, and then we'll expand it to the audience, especially those people who have been sitting quietly or not so quietly during the other discussions. You can all feel free to come closer also if you want to make this a little bit more intimate, or whatever the right word is. I will also say that unfortunately Ambassador Alan Baker canceled out, so we have Professor Erwin Kotler, Jessica Montell from B'Tselem, Daniel Tav from the Israeli Ministry of Foreign Affairs, Professor Ruth Redgewood from Johns Hopkins, and Irit Khan, Advocate Irit Khan, Deputy President, International Jewish Lawyers and Jurists Organization, and formerly the head of the international branch of the Ministry of Justice. We have people with a great deal of experience, a great deal of knowledge, and I think this panel will add a lot to our understanding and examination of these issues. To open up the session, I'm asking Jessica Montell to make a presentation. You still need me?
Hello. As I'm coming from the NGO perspective, and I thought to give you some examples from the experience of B'Tselem in NGO advocacy, what I thought would be most important to focus on in this presentation is to look at the relationship between domestic advocacy for human rights and international advocacy for human rights, some of the pitfalls and opportunities when looking at the two together. And I'll speak obviously from the perspective of B'Tselem's work. It's interesting to think back when B'Tselem was founded 19 years ago, almost all of our advocacy was domestic. We only had very passive interactions with international actors. We distribute our material in an extremely limited distribution in English. Almost everything was focused inward. Today that no longer is the case. B'Tselem has extensive contacts with international actors throughout Europe and in North America, both policymakers, organizations, judicial bodies, really across the spectrum. And most recently we opened an office in Washington, D.C. in order to insert human rights into the political conversation, diplomatic conversation in Washington, and in order to foster conversation about Israel's human rights policies among the American Jewish community. And I think this change from primarily domestic focus to a much more inclusive international focus is one that many human rights organizations have undergone, both in Israel and around the world. I think it's indicative of the understanding of the relationship between the two. In fact, it's not even obvious or easy to distinguish what is domestic advocacy and what is international advocacy. Almost any domestic effort to change policies that violate human rights requires some element of international advocacy as well. I think this is true for most advocacy efforts around the world, most country-specific issues around the world. It certainly is true when you're talking about advocacy regarding Israel's policies in the West Bank and Gaza Strip. Now, of course, that doesn't mean that there aren't pitfalls in this, and certainly when it comes to Israel, advocacy on Israel in the international sphere is unlike advocacy any other place because of the high-profile nature of this conflict, because of the constituencies mobilized around the world on behalf of both sides to the conflict, because of the material interests of very many international actors in this part of the world. It's clear that there are both opportunities and dangers to this advocacy that you don't have in other contexts. And certainly those human rights organizations that are doing this kind of advocacy are very well aware of which are the actors that are effective advocates, which are the actors that are credible, can be influential, and which are those that, because of one bias or another, have lost credibility or are not actors that human rights organizations want to engage with. Maybe I will just give two case studies from B'Tselem's work that I think indicate many of these points quite clearly. And I'll start with the issue of the separation barrier. We have published extensively on the barrier. I won't give a very lengthy presentation on the barrier itself, the human rights critique of the barrier, or even the whole history of the barrier. I'll just indicate 2 or 3 highlights from this advocacy. Beginning in 2002, the Israeli government began approval of the construction of a physical barrier between the West Bank and Israel, articulated at that time in order to prevent terrorists from entering Israel. In the initial stages of construction of the barrier, there was very little information actually about what the route was, who actually was even deciding the route, all sorts of basic information that you would think should be available to such an extensive, serious public works project for the State of Israel. B'Tselem was extremely active in documenting both the facts on the ground, where actually the bulldozers were working to construct the barrier, what were the decisions behind the barrier, how much it costs, as well as looking at legal and human rights implications of the barrier. In the summer of 2004, you had 2 decisive decisions regarding the barrier. One is the decision of the Israeli High Court of Justice in the Beit Suri case, a precedent-setting ruling of the Israeli High Court of Justice, and 10 days later, a ruling of the International Court of Justice, referred by the General Assembly in advisory opinion, on the separation barrier, security fence, apartheid wall, whatever official term was referred to in each of these decisions. Now, the Beit Suri judgment was extremely important in that it established the principle that even legitimate security measures have to not cause disproportionate harm. And this gets back, it's too bad that Amichai didn't have time to go into, in his last discussion on proportionality, about the separation barrier. It's one of the few high court rulings where the court stood up to those who said this is essential for our security and said that's not good enough. And the specific ruling on Beit Suri, looking at a very small portion of the barrier, in fact required the army to reroute almost the entire route of the barrier. Today, while I still have a lot of concerns about the specific route chosen for the barrier, it is far superior, causing far less harm to Palestinians, less expensive for the Israeli taxpayer, and from all perspectives, a better route than the one that was initially chosen to be built and was being built in 2003 and the beginning of 2004. Now, I think it's not coincidental that this surprising, even brave, and exceptional, unusual ruling of Israel's High Court of Justice came just 10 days before the ICJ ruling. To me, it seems fairly obvious that the threat, if you like, of the ICJ ruling played some factor in pushing Israel's High Court to issue a ruling that has had very positive implications on the ground. The second example I want to give, just to provoke discussion, and I don't have time to go into, again, a very detailed analysis, is the issue of punitive house demolitions. Up until 2005, you had an Israeli military policy to demolish houses of people who attacked Israelis. It could be suicide bombers or people who engaged in any other sort of attacks against Israeli civilians or Israeli soldiers. Their house would be demolished. Now, it's not the criminal who's being punished. Obviously, it's the relatives of the criminal. For me, as a human rights activist, as an Israeli citizen, as a human being, I think it's probably the most shameful of all Israeli policies regarding human rights. Again, violating the very principle that you don't sacrifice innocent people in order to achieve some goal that is unrelated to them. It's a policy that human rights organizations worked against, both monitoring, documenting, filing petitions to the Israeli High Court, as well as conducting international advocacy for many years. At the end of 2004, the Israeli military set up up a committee to re-examine the policy of punitive house demolitions. The committee was headed by General Udi Shani. At the beginning of 2005, General Shani released his conclusions and recommendations. The conclusions were not made published, but what I understand from what was reported in the press, and now in light of this new court case taking place at the High Court of Justice in the attempts to renew the policy, General Shani's committee came to three main conclusions. Number one, there's no clear indication that punitive house demolitions are effective as a deterrent. Always before, when we had criticized the policy, they said, we don't have very many tools that can be effective in stopping suicide bombings. People who don't care about their own life, maybe if they know their family will be made homeless, they will think twice. So General Shani said, no, there's no clear evidence that in fact this policy is effective. The second conclusion, in fact, the opposite. There is clear evidence that it increases the hostility of the Palestinian population, increases the motivation of Palestinians to attack us. So General Shani's conclusions are it's not a security asset. In fact, the policy is a security liability. And the third conclusion is that the policy harms Israel's international reputation. Again, a military committee also weighing the harm to Israel's international reputation of the policy. On the basis of those three conclusions, General Shani recommended to the Minister of Defense that punitive house demolitions be halted. In February 2005, the policy was halted. So that's the good news, that for the past 3 years we haven't had this policy which so seriously damages both human rights, I think the very underpinnings of Israel as a democracy and law-abiding country, and also a policy that the military concluded was in fact harming Israel's international reputation. To me, again, it's very clear that this harming Israel's international reputation played some role in encouraging the army to reevaluate this policy. And then I think we need to really think twice about this idea about what is good for Israel. That the idea that not making Israel look bad is necessarily and always correlated with Israel's best interest. In fact, in the case of punitive house demolitions, we see that the opposite is the case. I mean, to very much simplify the equation, if by making Israel look bad, Israel re-examined and canceled a policy that was in fact harming Israel's security, then the people who are making Israel look bad are in fact doing a service to Israel, not only in the sphere of human rights and democracy and the rule of law, even in the sphere of security. I think I will conclude there, and we can follow up on these points later in the discussion.
I'm not going to introduce everybody. I will let them either introduce themselves or go on.
Hi, good afternoon. Daniel Taub. I'm the Deputy Legal Advisor in the Foreign Ministry. Last week I had the dubious honor of sitting on a stage in Geneva before a new human rights mechanism which is called the Universal Periodic Review, defending Israel's human rights record before the Human Rights Council and effectively all the countries of the United Nations. And it was a very strange experience. I went in the morning of our performance or our appearance and saw the United Arab Emirates being treated with kid gloves. Every question beginning with great deference to their representatives and congratulating them on their great strides towards human rights protections. And not that I was exactly expecting the same thing to happen when we took the stage, but still to hear the representative of Yemen beginning their question with, "Never in the history of humanity have human rights violations been committed to compare with," etc., etc. To hear the Syrian representative tell us that only Jews were allowed to be citizens of the State of Israel, and so on and so forth. And usually when I speak at panels organized by Gerald, the question that I address is, how do we as Israel navigate in this environment? How do we, in forums where there seems to be a magnetic attraction in our part of the world that distorts the world's moral compass, how do we balance, for example, this terrible dilemma of, on the one hand, influencing the outcome, and on the other hand, not giving legitimacy to institutions that we think have fundamental flaws. And that's something that we can talk about. But today I actually wanted to ask a different question. And the question that I wanted to ask today is that even with bias, lack of balance, hostility in international fora, there still is a genuine and important dialogue that needs to take place on human rights issues. And if we're not going to conduct it with these fora, who are we going to conduct it with? And how are we going to conduct it? I mean, as I was sitting in the UPR, I was thinking that not every criticism of Israel, whether it relates to the Bedouin, whether it relates to the non-implementation of the OR committee recommendations, whether it relates to also, not every single criticism of Israel necessarily comes from a place of hostility and anti-Semitism. And so the question is, how do we take this on board? How do we find a mechanism for discussing these issues? I mean, sometimes it's very convenient to have this sort of bias. I remember Yehuda Blum, when he was ambassador in the United Nations, was attacked by Cambodia for Israel's human rights record. And he said this was a wonderful example of Pol Pot calling the kettle black, which was a wonderful response, but it's really not, it's not adequate. And earlier this year at a different panel organised by the JCPA on law and legitimacy, I suggested a number of questions that we might want to ask if legal principles were used against us, how we could gauge the legitimacy of the use of those principles in a campaign. And so today it occurred to me that maybe there are a number of questions that we can ask of partners in a dialogue on human rights issues that maybe are some sort of litmus test to gauge whether this is a legitimate and authentic dialogue on human rights issues. And I want to say here, I want to say it to Jessica, I want to say it to anybody in the NGO and human rights community. The idea here is not to rule people out of the dialogue, but as somebody who is inside the system to share some thoughts with you on how to be effective in engaging with the Israeli authorities. As a lawyer for the government, in a sense, I'm two-faced. You might say all lawyers are two-faced, but I'm two-faced in the sense that I spend a certain amount of time speaking to the international community and defending our record. But I also turn round and defend international law as a factor to our government. And so the question is, how can human rights institutions, how can NGOs help us in that second conversation? How can you support your allies in the system? So very briefly, I'll just do it in a manner of headings. I'll share with you the questions that I thought would be useful, and the questions that I think it's legitimate of an Israeli general or an Israeli policymaker to ask when he's getting advice from a human rights institution or from an NGO. First of all, and I won't go into it in great detail, it's been discussed at length today, how does this institution allocate its resources? And again, here I'll share a comment with you. I don't think it's as simple, I have to say, as simply saying the areas of greatest humanitarian need have to get the greatest attention, although it would be very convenient for us to say it. It's obviously a complex calculation in the same way as in the health system. You don't spend all your money researching only the most serious diseases, because sometimes you see opportunities for making greater progress in other areas. But if that's the case, if you feel you can make greater progress in relation to Israel because it's an open society, because you have access, because it has a free press, then that should be reflected. It should not be the sort of dialogue that we have with so many NGOs that say, of course we hold you to different standards because you're a democracy, but you never see any trace of that in their reports. Secondly, the question of the mandate. The question is the mandate universal. It's quite clear that justice selectively applied is justice denied. If you are actually going to address human rights violations, they have to be addressed across the board. And that's not only a question of fairness or balance, it's also a question of context. It is not enough, like Human Rights Watch, to issue one report on Israel's conduct in the Lebanese war and one separate report on Hezbollah conduct. Because if you're going to assess questions of proportionality, the two things are actually integrally related. You can't simply discuss these two things in isolation, one from the other. If you take the medical analogy again, You take any medical operation, if you take the illness out of the equation, you're going to be left with an assault in every circumstance. If you're actually going to be trying to address these issues in a serious way, you have to have a universal, broad-based approach and see how these things fit together. Obviously, this is also important from a psychological point of view. I am trying to advocate your case to a general, to a government official. They want to know that their concerns have been heard before you go ahead to make practical suggestions or otherwise make recommendations. Secondly, what is the expertise that you bring to the table? Frequently, when there is a clash of human rights and a difficult balancing act, you are not simply balancing different rights, you are balancing different areas of expertise. And it is not helpful to have an analysis or a series of recommendations that only comes from a group of people that have expertise from one end of the spectrum, maybe the Human Rights Convention's end of the spectrum. And it is puzzling to me that not more NGOs and not more international human rights mechanisms take advantage of people that have genuine military expertise or police expertise to try and give them some sort of guidance on what is practicable, what is manageable, what is legitimate, what is reasonable in a particular circumstance. Because it makes it so easy for people to dismiss their findings as being people who are disconnected from reality. What it means is that in practice we find ourselves conducting two sets of dialogues in parallel that have almost no connection between them. I can think, for example, of one third world country with which we can engage in counter-terrorism dialogue on the one hand, and in the counter-terrorism dialogue, for example, where we have a lot of interest to share, I sometimes share with them some of the findings of our Supreme Court. And here again, I have to disagree with Jessica. I don't think it's rare in the Beit Zurich security barrier case that the court found that there were limitations on what Israel could do in its security. I think there have been dozens and dozens of cases where the court has found that, maybe not to the extent that some people would like, but I think that's been a recurring theme of judgments of the Supreme Court. But I shared these decisions with our counterparts, and they look at me like, are you guys out of your mind? And yet we'll find representatives of this same country in international fora, in human rights councils and so on, wiping the floor with us, criticizing us for gross violations, disproportionate and so on. There's simply no connection between these two dialogues. And it's clear if we're going to be effective, we have to find some way of conducting these two dialogues simultaneously. The next question is, does this institution, if it's an NGO, if it's a human rights forum, have practical suggestions to make? I think now of the special rapporteur that we heard about earlier, Richard Falk, his predecessor, John Dugard, who wrote 8 very, very extensive documents on human rights violations in the territories. I cannot recall in any one of those documents a single measure that was taken by Israel that he found to be either legitimate or proportionate. He would say things like, in relation to the tunnels coming from under the border between Egypt and Gaza, I am sure that Israel, with all its high-tech experience, it has, techniques that could address this problem in a humanitarian way. That is not a practicable solution. If you want Israel to change its policy, help Israel change its policy. Have a look around the world, look at best practices, consult with other armies, consult with other security services, see if there are countries that are facing similar threats that have found methods that are more effective and more humanitarian. Simply to say with no military expertise it's disproportionate and we expect you to invent something that can do this better simply isn't an appropriate case. I'll mention very briefly a couple of others. Here's a very important one. Does this institution, does this NGO mention the good things as well as the bad things? There are frequently measures that Israel takes that go above and beyond humanitarian standards as required by international law, as reflected in customary international law in the ICIRC manual or encyclopedia of international law and so on and so forth. If an organization is not prepared to recognize, along with the criticism, improvements, progress and so on and so forth, first of all, I think it reflects an element of dishonesty, it reflects a political agenda. But more to the point, practically, if you're trying to get people, decision makers, over onto your side, it's psychologically a tremendous missed opportunity. I'll mention three last things. The first one, which I would hope would go without saying, particularly in relation to NGOs, unfortunately in our region it doesn't. Does it obey the law? Unfortunately, when you see organizations like the ISM, which have on their website, the International Solidarity Movement, advice for how to lie to the immigration officials so that you can actually get into the country, I don't think you as an NGO can expect to have a respectful dialogue with a country when you don't simply respect the basic laws of the country. Secondly, if misinformation is published, and it's in the norm of things that there will be factual errors, do you publish corrections with the same degree of effort and publicity that you published the original report? I think the basic standards of ethics that apply to the media should apply to NGO bodies. And finally, and here I'll comment again on something that Jessica said, the question of who is your audience. And the question has to be, do you speak to the audience that is most legitimate and most likely to bring about an outcome? I don't rule out the possibility of speaking to the international community when there's no other choice. But I think first and foremost, if you're an Israeli organization, your dialogue should be with the Israeli authorities concerned. And here again, the thing, for example, in the security barrier case, that resulted in the dramatic change, far more than the shadow of an ICJ advisory opinion 10 days later, was actually an alternative route that had been prepared by a group of ex-generals who had tried to take on board Israel's security concerns and went to the court and said, we can meet these concerns with an effective barrier. To my mind, that's a very effective model of genuine humanitarian dialogue, far more than running to the international community and trying to generate international pressure. I have to finish. Every time I speak to Bar-Ilan, I feel some sort of obligation to look in the week's parasha and try and find something that relates to the issue under discussion. This week there was no problem whatsoever. It's very, very striking. It's the week in which Jacob fights against Esau. But of course, before Jacob fights against Esau, there's another fight that takes place. And that is the fight that takes place the night before he meets him, when it says that he was alone and he fought with a man. And it's very strange, why was he alone? How could he fight with a man when he was alone? Which leads some commentators to assume that the person that he was fighting with was himself. I think the lesson here is the lesson for Israeli authorities, Israeli government. Before we can go out and engage in battle with the international community, we actually have to engage in a genuine soul-searching, a genuine struggle within ourselves. And as genuine and as forceful as that struggle is within, will be our credibility and our conviction in the struggle without. Thank you. Professor Ruth Wedgwood.
Well, it's a great pleasure to be here with so many friends I haven't seen for a while, and including Irwin, the great Irwin, and others, and new friends. I'm here, I guess, in part as a participant anthropologist reporting from the battle scene. I got elected to the Human Rights Committee about 5 years ago, much to my surprise, frankly. Life never works as you would plan it. When I was logical to elect, I wouldn't have gotten elected, but inshallah. And I thought I would just, from an inside vantage, talk a little bit about, if you will, kind of a subjective institutionalism, what it feels like, how it seems to be effective, what its limitations are, what our sister bodies seem to do and not do. The little humble group on which I sit is one of the 9, now there are 9 treaty bodies, purportedly independent experts, academics, retired judges, sometimes retired diplomats, occasionally an active diplomat, which ain't so good, elected by the states' parties under each of the various 9 human rights treaties, the civil and political rights, the economic, social, children, women, torture, race, handicapped, migrant workers, and disappearances. To look at states in their periodic reporting, you can imagine that a small, newly independent state at $1 million a report finds 9 committees a little much to cope with. It is right to observe that many states sign up for the whole enchilada, just on the view that, more is better and it looks better to UNICEF and UNDP, and we'll worry about capacity building and compliance later. And that is a worry and a problem, this kind of formulaic club joining where even a very good faith state is overwhelmed. But the theory is that reporting will be the occasion for self-examination at an interval of every 4, 5, 6 years. And at least in our little committee, we do push the state to the extent they can to be as empirical as they can. We don't just want reams of statutes from Tunisia, but we want to know about actual numbers of people in prison and whether there are trials and who's been tortured. And that, you discover, is actually the Achilles heel of much of human rights compliance. States are not transparent. They bury in states through most of the world. They don't know their own practices. They don't collect data. If they collected it, they might not tell you anyway, but they don't collect it. They do not know in Kenya how many people died of AIDS in jail, say. So I do think, to some degree, the High Commissioner's been justified in thinking that some human rights monies should be given to states to become a little bit more self-transparent. But the theory is that compiling the reports and then coming to Geneva to be talked at about the reports will be an uplifting experience. It certainly is if you can get the police chief and the prison guy to come, because then you can do your yo mama act and say, I've been there, I've done that, and here's a better way. If it's just the Human Rights Commissioner who comes to you, you've been blown off, frankly. It's nice to have someone come, but you worry that you've lost something in the attenuated translation through a person who will be perceived in the security side of the government as overly aspirational. One problem, though, with the reporting mechanism is that many states just don't report. And we tend to do the work that's put in front of us. It's easier to take Belgium at 4-year intervals than to worry about Gambia, Zambia, whoever hasn't come along, and then try to cobble together an in absentia report on those absent states. So if somebody was a statistically minded person, looked at the periodicity of states that don't report and how often they're taken up in the absence of their report, you'll discover, I think, that it's very low, and that's dismaying. The other thing that I do concur in, I think it was observed already, was that sometimes the activity is exceedingly self-referential. We generate paper. We are good at making paper, and then we translate it into at least 3, if not 5, authentic languages, and report it to the General Assembly, where you can buy it for $39.95 in the UN bookstore. What we're not aware of is the cultivation of a real constituency. I've been gently pressing my colleagues for quite some time, whether it's Marshall McLuhan, the message is the medium is the message, the process is the product, that it would be far more engaging, uplifting, Orange Revolution for young folks in Africa to hear the proceeding, to hear that the Central African Republic has to actually come before someone and give answers to questions, to hear that on iPod, on the radio, on a website, than to try to read and give sense to dry and desiccated, isolated, concluding observations in a document. So I do think that to the extent the UN's been slow to get on the web at all, one thing it absolutely must do is make human rights reporting something that's vivid and visual and dramatic. And yes, we would probably become even stagier than we are with more Patrick Henry speeches. But that may not be to the bad, actually, because I do think it would give comfort to the great many countries in which there's still doctrines of criminal libel and lèse-majesté and controlled internet, to younger folks to be confident in taking a slightly oppositional attitude toward their own governments. On compliance, how do we measure it? The good countries come around every 5, at least the bureaucratically efficient countries come around every 5 years. There are always reliable issues. If you have a European country, you can count on there being some Roma issues. Everybody's got police violence. Everybody has torture issues. But we don't actually do that much longitudinal tracking, except through the memory of members who happen to have stayed on the committee for a very long time. Then there are the cases, which a certain number of committees have. We have them in civil and political rights. There's a new individual communication petition mechanism in economic and social. It will be interesting to see how you order India to provide K through 12 education. Torture has it as well. And in those, one interesting question that one could put is, how do victims get selected? Oftentimes we fulfill the function both of a legal aid bureau and of the adjudicatory bureau with the same staff, which, and with real problems of fact-finding. We can't have oral argument. We have a very formulaic he said, she said between the state and the victim, and when it's time for decision, there's no more time for questions. So it's certainly not as satisfying as being on a hot bench in a real court of appeal. On the other hand, I think the kind of immediacy of a torture case from Uzbekistan or a police violence case from somewhere in Africa can give a cogency to it. Anybody who's on such a committee, though, since we're all academics at heart, has to beware of the temptation of the pen. You know, it's one thing to be there as an old, retired, washed-out trial lawyer, but for folks who are academics, they want to make law. And we do, I think, often do a progressive development of the instrument to a degree that some might or might not agree with. I do believe that there is a kind of progressive, consensual corpus of understanding that can surround a written document as it changes over time. But as academics are rewarded for novelty, so too, I think, in the human rights community, sometimes it's too dull to apply the old tried and true norm to a changing set of facts. Rather, let's make some new substantive law. And that, I think, is an interesting problem. One, if you take, for example, the issue of reservations. When you enter a treaty, you can take a reservation, so long as it's not a violation of jus cogens, doesn't frustrate the very purpose of the treaty, but you can take a reservation to accommodate some small carbuncle of local law. But if we change the interpretation on you, I'm going to invent such a doctrine, but at least at the moment, there's no doctrine of dynamic reservations. You'd have to leave the treaty and come back to take a reservation. So that should probably be a halter on how quickly we gallop, but at the moment it's something that leaves states somewhat surprised at times. If you ask me, do I think it's efficacious? I wouldn't waste all my time, 9 weeks a year, if I thought it was just an exercise in complete futility. How do you know you're talking to Erwin? Because he smiles at you. And you at least have some illusion that when the Russians come in with these big, bruising guys, like they did right before they arrested Khodorkovsky, and they bring in the interior minister, including and the president of Chechnya, shortly before he's assassinated, you feel like you're talking at least to the guys who have the levers that wield the power. How you judge it after that, I don't know. But there are very few, at least from the point of view of a normal actor, there are very few occasions when you can confront major ministers up close and personal in a room with all the arguments from pragmatism as well as idealism that you hope will sway people. Doesn't change their domestic calculus necessarily, but if you think language has any efficacy, then other than having a 3rd Infantry Battalion behind your words, this is probably as good an occasion for persuasion as you can have. On the Human Rights Council, which I see from more of a distance, there the U.S. got it, I think, badly wrong, I'm afraid. We were eager to reduce the size, which we did, but we didn't count the votes. You know, you can't be in Chicago politics if you can't count the votes. Count the votes. Jan Eliasson didn't count the votes. And it was indeed completely predictable as it came out that the West would be worse off than it had been even in the Commission. And my other grudge, I suppose, is that you can only restart the engine so many times. So you used up the occasion for reform. I therefore, with loving him deeply, nonetheless begrudge Jan Eliasson his urge to have this achievement before he left office in his one term as General Assembly President. Ditto for the Secretary General. One should have taken more time to get a better result. Now the best that can be thought is to either expand it and dilute it by taking it back to the full plevy of countries, which would dilute the effect of certain regional groups. Or, well, I don't really have an or. I think that my statement is not U.S. policy, I think, but... U.S.
policy will change soon, probably.
Yeah, I'm not sure. My other view on my own country is that I would simply engage more even as a non-member. You can do a 3-minute speech as a non-member. You can have your auteur and eat it too by intervening. I mean, universal periodic review ought to be good. The problem is that the rules were set by a relatively indifferent, if not hostile, phalanx of countries in the Council Now the NGOs are limited to, count them, 10 pages of summary of their recommendations. All the special rapporteurs and human rights organs that have observations are limited to another 10 pages. There's no live participation by the NGOs in the examinations. And if you're a jurisprude, the worst part perhaps is that at the end of the session, the target or subject country will adjourn to a dinner coffee klatch and negotiate which ones of the recommendations they intend to accept, therefore implicitly politicizing all the recommendations, even ones that one supposes are really quite clear as a matter of legal obligation. So it's not a good thing. But I do think for Israel's sake, the more you engage, the better. The more you have, in fact, cogent empirical arguments, the better. I was chiding my friend Daniel that at the Human Rights Committee presentation, oftentimes friendly questions that were asked with an implicit yearning for empirical description of how one thought about the issues of arrest versus kinetic disablement. There was no data forthcoming about decision processes or numbers, and that did not help. On the High Commissioner's Office, this is a job that no one's ever succeeded in getting quite right, as you know. My own view, I guess, is that one only has a certain amount of political capital to use in that job, that at the moment, with the vocation of getting the council better, a high commissioner really has a moral, legal, institutional obligation to engage deeply in council politics, not to be corrupted by it, but not to stand aloof, as I'm afraid the last high commissioner did, while it forms its own method of work. And finally, I think don't forget the regional organizations. The attempt to stand up an African Court of Human Rights, the very, very interesting opinion that was just handed down by the ECOWAS Court of Human Rights, which found, in fact, against a case of slavery in Mali, where the j'accuse quality that so riles the South, this is preaching from the north to the south and the west to the east, that if it's a local voice, if you can get it, it's highly efficacious. It's got the suasion of economic partners and regional neighbors and regional politics. So if you can get the African Union to do it, so much the better. One should not make this a European exercise in a kind of multilateral moral colonialism. And the Inter-American courts have done just fine. There is no Asian court. But I would make every effort to have a real set of African courts stand up and do this work. You see it, final observation, I'll shut up, that even now in the ICC, as Luis Ocampo, who's been very good, has only largely brought African cases, there's been a pushback. And you'll get that, too, in human rights exercises, unless you succeed in cementing these as voluntarily embraced local norms. Thank you.
Professor Owen Kotler, I did the introduction last night. And it certainly means no introduction.
You know, in addressing the topic of assessing the effectiveness of the human rights regime, I'm reminded of a book written by former priest, congressman, scholar, advocate, Father Robert Drinan, written 20 years ago, called The History and Hopes of the Human Rights Revolution, whose main thesis is that the present elevation, as he put it, of international human rights into an international juridical norm has been the most dramatic development in the history of contemporary jurisprudence. That was a kind of salient theme of his book at the time. Indeed, it was a almost prescient sense of the dynamic developments in international human rights law and the regime of international human rights of the last 2 decades, which have included, among other things, the internationalization of human rights and the humanization of international law, the explosion almost of international human rights standard setting and treaty making, the establishment of international criminal tribunals for former Yugoslavia and Rwanda in order to criminalize mass atrocity, the development of an international criminal court as kind of one of the most important post-Nuremberg initiatives, the dramatic international jurisprudence of these international criminal tribunals and other tribunals wherein rape in armed conflict is characterized variously as a crime against humanity, as an act of torture, or even in the Akayesu cases, maybe constituting an act of genocide. The principle of non-immunity for heads of state, UN Security Council resolutions with respect to the protection of vulnerable people in armed conflict, the proliferation of mechanisms for the purposes of both monitoring and enforcing human rights law, and the like. But I suspect, and I was beginning to see eyes rolling as I was giving you a snapshot of the international human rights revolution, that some of you may have been thinking to yourselves, but too polite to scream out loud, who is this guy? Is this what they teach in the ivory towers of academia as they begun to imbibe the platitudes of politicians? Doesn't he understand what is happening to real people on the ground every day? And indeed, if one looks at the situation on the ground, the assaulted of Africa, the imprisoned in Asia, the terrorized in the Middle East, the refugees of humanity, the violated women, the battered child, each and every one of them can be understood if they feel that this human rights revolution that I've described has somehow passed them by. While the genocidal acts in the Balkans, the unspeakable genocide in Rwanda, the genocide by attrition in Darfur, the mass rape in the Congo, each and all of these and more are metaphor and message of the abandonment of this human rights revolution. And so it's not surprising, therefore, that all this talk about an international human rights revolution tends to invite the not uncynical rejoinder in Benthamite terms that international human rights law is so much nonsense on stilts. That is, rights without writs, rhetoric without remedy, semantics without sanctions, standards that morph into double standards, and the like. And so, on the occasion, therefore, of the 60th anniversary of both the Genocide Convention and the Universal Declaration of Human Rights, the kind of dialectical encounter of an international human rights revolution on the one hand, but the continuation of mass atrocities on the other, I think it's appropriate to ask ourselves two questions. What have we learned, and what must we do? And what I would like to do is share with you briefly 4 dangers or assaults on the human rights regime in terms of the lessons learned and the action to be taken. And as case studies of our generic theme today, namely of the effectiveness of the human rights regime. The first danger, and this was the substance of my remarks yesterday evening, is the danger of state-sanctioned incitement to genocide and the responsibility to prevent. In a word, the enduring lesson of the Holocaust and the genocides in the Balkans and Rwanda in Darfur is that these genocides occurred not only because of the machinery of death, but because of this state-sanctioned incitement to hate and genocide. As the Supreme Court of Canada recognized, as echoed also in international tribunals, the Holocaust did not begin in the gas chambers. It began with words. These, as the court put it, are the chilling facts of history. And so, with respect to these genocides, what one can say is, in each of these cases, the genocides have already occurred. But we are witnessing today in Ahmadinejad's Iran the toxic convergence of both a genocidal and nuclear Iran, the epicenter of the present contemporary state-sanctioned incitement to genocide. And with respect to that, we released yesterday a petition called "The Danger of a Genocidal and Nuclear Iran, the Responsibility to Prevent," endorsed by leading scholars and jurists and genocide experts and survivors of killing fields all over the world, which was organized around 2 parts. The first part was to set forth, and I think this is a rather unprecedented documentation, the evidentiary record with respect to the state-sanctioned incitement to genocide in Ahmadinejad's Iran. We identify 7 precursors to genocide, and of which I spoke yesterday evening. And all I can say is, as someone who was at the time that I was the Minister of Justice and Attorney General of Canada, prosecuted Rwandans for incitement to genocide. There are more precursors to genocide in Ahmadinejad's Iran than there were in the Rwandan case or in the Balkan case and the like. And so the second part of our petition calls upon state parties to the Genocide Convention to undertake their responsibilities, because the Genocide Convention obliges state parties to prevent this incitement to genocide prohibited by the Genocide Convention. And indeed, one of our signatories, Madam Justice Louise Arbour, in the course of supporting this petition, said it must be appreciated that the responsibility to prevent is an international legal obligation. More than it is a matter of jus cogens, of overriding international law. Yet, as we meet, not one state party has invoked any of the obligatory remedies to bring Ahmadinejad's Iran to account, and we identify a panoply of remedies in the petition. Not one international United Nations agency has even addressed this question. In other words, the responsibility to prevent is nowhere to be found at this point with respect to addressing the dangers of a genocidal and nuclear Iran, which brings me to the second lesson, and that is that these genocides occurred not only because of the state-sanctioned incitement to hatred and genocide of which I've spoken, but because of indifference and inaction in the face of such incitement. And again, when one looks at the situation at this point in terms of the genocides that have occurred, the horror of these genocides, for example, using Rwanda as a case study, is not only the fact of the genocide, whose name we should even shudder to mention. The horror is that these genocides were preventable. Nobody can say that we did not know. Just as nobody can say that we do not know what is happening in Darfur today. Similarly, with respect to Ahmadinejad's Iran, nobody can say that we did not know. Though people do say that they do not know, in part because we so focus on the nuclear dimension that we ignore or sanitize the genocidal dimension. But the danger of the nuclear dimension is because it is connected to, against its backdrop, is the genocidal Iran. In fact, Iran always denies that it is in fact developing atomic weapons. It says that it is only engaged in the development of the peaceful uses of atomic energy. And that is why for some people, they say, well, why should we really be sanctioning Iran for seeking to do that which anybody else wishes to do? It's only in connection with its genocidal incitement that it acknowledges that in fact it would take only one bomb to wipe Israel off the map, so that the genocidal incitement here links up with and connects to the nuclear dimension as well. And so in that regard, our approach yesterday was not to launch the petition as a one-time effort. Launch it yesterday and that ends it. No, it is to be for us a sustained international advocacy project. And I say a sustained international advocacy project because what we're involved in here is, on the one hand, with respect to making the case as to the dangers of a genocidal and nuclear Iran, is to break the silence, to sound the alarm, and with respect to the responsibility to prevent, to identify the obligatory remedies in the Genocide Convention and international law. And I say this because I just want to give one anecdotal reference that I think makes the case of why this has to be a sustained advocacy project, in which we are, to begin with, identifying 13 states whom we will seek to get to be the first of the states that we hope will begin to invoke these remedies. It occurred in April 2004, when I was then Minister of Justice for about 3 months and attended a meeting in Washington, G8 meetings of Ministers of Justice and Attorney General. The United States was the host, and John Ashcroft, the then Attorney General, was hosting the meeting. And when I looked at the agenda, this is April 2004, genocide by attrition in Darfur was at its peak. I looked at the agenda, not a word about Darfur. So I said to John Ashcroft, you know, we're meeting here, we're having a G8 meeting. there isn't any reference to Darfur on the agenda. And he said, well, you know, the civil servants drew up the agenda. We are only to deal with the agenda drawn up by the civil servants. He said, it's too late to change it, but I'll tell you what, he said, we're having an opening dinner, an informal dinner. I'll let you say a few words about Darfur. I spoke about Darfur, but the interesting thing about it is as follows, and that's why I'm mentioning this. After the dinner, when we talked amongst us, 4 out of the 8 ministers of justice did not know and said they had not heard about the genocide in Darfur. In other words, politicians live in a bubble. You have to break that bubble if you want to make the case. The second thing is, none of them almost, none of the 8, even those who knew or were prepared to characterize it as a genocide, knew that they had obligatory responsibilities with respect to prevent that genocide under the Genocide Convention. That's why I say that we have to be engaged in this sustained project. Let me go to the third lesson, and I'll go very quickly now to a close, and that is the assault on human rights and the effectiveness of the human rights regime through the culture of impunity that persists today. In other words, if the 20th century and the first decade of the 21st century was the age of atrocity, it has also been the age of impunity. Few of the perpetrators have been brought to justice. And even with respect to the mechanisms set up in order to bring perpetrators to justice, it is, to this point, shown to be both imperfect and inadequate. For example, in terms of the International Criminal Court, one of the most dramatic developments in international criminal law since Nuremberg, as I mentioned, there has yet to be one trial under the International Criminal Court regime. In terms of the International Criminal Tribunal for former Rwanda, you speak to Rwandans, they feel a disconnect with respect to that tribunal. With regard to the International Criminal Tribunal for former Yugoslavia, the former president of Serbia, Karadzic, it took 13 years to be able to even apprehend him and bring him before the court. If we look with respect to the question of Sudan, it's astonishing. Sudan has issued arrest warrants, for example, for the Minister of Humanitarian Affairs, Ahmed Haroun, in Sudan, accusing him of having prepared and planned and executed genocidal acts in Darfur. What happened after the ICC issued an arrest warrant for Mr. Ahmed Haroun? The Sudanese government promoted Ahmed Haroun to become the Minister of Humanitarian Affairs, responsible for hearing the complaints from the very people against whom he committed the atrocities. What greater Orwellian inversion can you have here of law and language? And it is the same with regard to the head of the Janjaweed, against whom an arrest warrant was issued as well. And when the special prosecutor of the court said he was going to ask the court for an arrest warrant for the president of Sudan, al-Bashir, Bashir repudiated the International Criminal Court as not having any jurisdiction over him and the like. And similarly, with regard to Ahmadinejad's Iran, the culture of impunity prevails. I don't want to say that there have been no advancements. Even in what I've said to you, we do have a special prosecutor of high caliber and intensity with regard to the International Criminal Court. There have been important precedents in the International Criminal Tribunals for Rwanda and Yugoslavia in some of the matters that I mentioned in terms of rape and armed conflict and the like, and I can go on. But the main point is that for the most part, the culture of impunity remains, which brings me now to my final lesson in terms of the assault on human rights and the effectiveness of the human rights regime. And I'm speaking here in terms of that assault on human rights, which emanates actually from the United Nations in general and from its own human rights institutions in particular. Let me say that I grew up, in a sense, as a child of the United Nations system. In other words, if you grow up as a Canadian, then the United Nations is held out to you almost from birth as an organizing idiom of Canadian foreign policy, as the international law is held out as the linchpin of the UN. Human rights is the banner under which, Canadians should always march, and so on. And if you grew up as a Jew as I did in the late 40s and early 50s, then there was a kind of symbiotic relationship between being a Jew, Israel, the United Nations Genocide Convention, Universal Declaration of Human Rights, and the like. Time does not permit to go into the symbolic and symbiotic nature of the relationship, but the point I'm trying to make here is I grew up with a kind of positive orientation psychologically, politically, legally, and the like with regard to the UN. 60 years later, in a word, I think what we find is a situation, and it has been best expressed by others, and principally by Ann Bayevsky continuously, is that Israel is singled out for differential and discriminatory treatment in the international arena. And more than that, at the same time, the major human rights violators enjoy exculpatory immunity together with this obsessive preoccupation with the singling out of Israel. None of this is intended to suggest that Israel is above the law or that Israel is not accountable for any violations of international human rights or humanitarian law. On the contrary, Israel, like any other state, is responsible for any violations of human rights and humanitarian law. But that's precisely the point. Like any other state. The problem is not that Israel seeks to be, that anyone should seek on Israel's behalf, that it should be above the law. The problem is that Israel is being systematically denied equality before the law in the international arena. Systematically denied, if one wants to use the term international due process in the international arena. The problem is not that human rights standards are being applied to Israel. They should be. The problem is that these standards are not being applied equally to everyone else. The problem is not that Israel should respect human rights. She must. The problem is that the rights of Israel deserve equal respect, and they are not getting it. I'm going to just share with you one experience. Daniel Taub mentioned the question of sometimes a dilemma in terms of experiences where you don't want to validate the process and you at the same time you want to influence the outcome and so on. I'll just give you one example of many that I can, but because of constraints of time, one example. 2 years ago, I received a call from the then United Nations Commissioner on Human Rights, Louise Arbour. She asked me if I was prepared to join. In fact, she was inviting me to join a two-person fact-finding commission of inquiry that was going to look into the deaths of 18 Palestinians in Beit Hanun as a result of an Israeli rocket attack. That's how it was characterized to me. I said to her, is this fact-finding commission of inquiry not only going to be going to Beit Hanun and Gaza, but is it also going to be going to Sderot? Because Sderot was, in fact, as I said, the object of rocket attacks by Hamas, and in its response, shells in an errant way and tragically did kill some 18 Palestinians. She said, no, the terms of reference are only for us to go to Beit Hanun. She said, Bishop Tutu is one of the members of the commission, you can be the other, and I believe if you're there, it'll help to give it a sense of a balance and the like. I said, Louise, I said, I've read the resolution, the United Nations the Council of Human Rights resolution under which this fact-finding commission of inquiry was established. It states that Israel wantonly and deliberately killed women and children in Beit Hanun. In other words, I said, you've predetermined the outcome of the very matter that you have set up a fact-finding commission to investigate. I said, I'm sorry. I said, I can't join that commission of inquiry. I'm not going to be a fig leaf for that kind of exercise. And frankly, I said, I don't think the United Nations should be engaged in those kinds of exercises. Now, the point is that what I was basically saying, and what I thereafter in conversation talked to her about, is that this was not only a matter, and generally speaking, what is happening at the UN within the Human Rights Council and the like, it's not just a matter of the singling out of Israel for prejudicial and discriminatory treatment. What is really happening here is, in fact, if people care about the United Nations, this is impugning the integrity of the UN, under whose protective cover this takes place. It undermines the authority of international law, under whose imprimatur it is being authorized. It stains the banner of human rights, under which credo it marches. And so, to close up, in a word, the integrity as well as the effectiveness of the UN human rights regime at this point stands exposed in its sanitizing or ignoring the state-sanctioned incitement to genocide in Ahmadinejad's Iran, in the indifference and indeed inaction in the face of mass atrocity, in its nurturing rather than combating of the culture of impunity, and as I said, in the singling out of Israel for differential and discriminatory treatment while human rights violators enjoy exculpatory immunity. Simply put, the integrity and effectiveness of the human rights legal regime is what is at stake. Those who care about Israel should in fact seek to promote the integrity and effectiveness of the human rights regime in all other matters that have nothing to do with Israel. And those who care about the integrity and effectiveness of the international human rights regime should ensure that that regime is not used and abused to single out Israel for differential and discriminatory treatment amongst the family of nations.
What can you say after such a speech that Erwin is giving? That, you know, that I'm identifying with everything. Well, the name of our lecture is really what is the result, or how do we look at human rights? And I don't want to go and to say things that have been said here, because there's so much that had been said. But when I looked at it, and I thought to myself, really, what happened with human rights 60 years after the Declaration and the Genocide Convention, etc.? So if I'm looking at Jessica, that she spoke about what happened in Israel and about the decision, I must tell you, coming from the Ministry of Justice, and that's why I'm here, because I was the director of the International Department in the Ministry of Justice, I remember very clearly one day when there was a Pinochet decision. Daniel, you probably remember too. And Alan Baker, the legal advisor to the Foreign Ministry, he had to be here, came to the Attorney General and said, we are starting a new period. This was with universal jurisdiction, if you remember. And afterward, we had the case of Sharon, and we knew exactly when it started with the Pinochet case that here we are exposed to those things. And it does influence. We have to open and to say it open-mindedly. We thought about our soldiers at that time. We thought about the officers in the army. And I'm not saying that until this point there was not a real discussion in the Attorney General's office concerning army actions. There was always discussions, can we do it, cannot we do it, when the international law was really the things that we wanted to follow. So in this respect, talking about the inside Israel, there is an effectiveness of those things. But when I thought about the question, I wanted to relate to it more globally. And here, Erwin, I'm going to take your second thought, that's saying, well, there was 3 genocides. It's exactly what I wrote in my paper. There are atrocities. And I asked myself a question where I went to criminal law in a state itself. And I'm asking, I said, there is a criminal law in the state itself in order to make an order in a state with internal law. That the punishment in the criminal law, is it effective? Is it successful? It's interesting. It's not. It's not deterrent. We see recidivism. We see that the crimes are going, and are growing. And then I went from this criminal law in the country into international law. We have international order in international law. We can't live without it. As much as we need the internal order in the state, we need international law to make order between the states. But it's maybe in the nature of human being what thing that we are seeing. Because who would thought that after the Holocaust in the Second World War, we'll have 3 genocide and terrible genocide that happened, as Erwin said, in Kosovo. And it was just now a movie in the CNN showing, because of the 60 years, those 3 genocide. And there was one colonel, English colonel, that was sent by NATO, I think it was to Rwanda. And he gave his impression that he wanted to do so much. He's sick now, mentally sick, but his hands were closed because the United Nations told him not to act because they were afraid that something will happen to the soldiers of the United Nations. And here I'm coming to your lecture that you were talking about it, and I identified so much with it. We can't only talk and say, well, we need human rights. If we want human rights, we need an institution or something to go ahead and to do it. Exactly as you said, Irvin, and I'm looking at the state of Israel, I think that you are the only prophet who goes all over the world and talk about Ahmadinejad. And you're absolutely right. It starts with word. There are decisions by the Rwandan court with the Tutsi and the Hutu about incitement to genocide, that's exactly what brought to it. And if you will see how the people there in Rwanda was called, and you look at Ahmadinejad, what he said about here, people in Israel, it's frightening in a way. And you say people don't know. Here you have the nuclear power, which the world don't know what to do. You know, as we say, someone is shouting and the train is going on, and that's exactly what's happening today in Iran, and I think that it's very, very serious. And Ahmadinejad is working in the United Nations, and 32 countries are listing them to be in the Security Council. And you ask yourself, where do we live? So you have a bad feeling when you look at it on this way. If we take other phenomena, like every place that I'm going on, I'm talking about Shalit, our soldier that is sitting, and I think that this conference has to relate to it very, very, very strongly. We have a soldier that sits at the Hamas 900 days, or 899, I don't know if I'm not saying it. Human Rights Declaration, there is not one thing that it applies about him. No one knows where he is. He's not writing letter. The Geneva Convention will speak about prisoners, speak about every 10 days a letter, visit, lawyer, nothing. And the world don't speak. Even Israel don't speak enough, I think. I'm not just speaking about the world. The world don't speak. So then you are asking yourself, we're developing the human rights, we are going forward. What's going here? What is it? No one is interested about it. Now, those things that you see that in one side there are such a neglect of human rights, and the other side you are so advanced, you have the council that asking of everything, you don't see the balance, and this is a very bad thing in the international arena. I want to tell you that one of the things that I think that is causing such a thing is the ignorance. I can tell you from my experience, when I was defending our Prime Minister Sharon at that time, I related to it as defending the State of Israel in Belgium. We could not go into the court because it was just the lawyers that could go in because of internal thing of Belgium. And I was standing out with all the people from the newspapers, of course, who wanted to come and to write about it. And the ignorance that I found by those people who are going to define Israel, there was no decision in the United Nations. We just came here and threw all the Palestine away. Now, once you write those things, it becomes so politically motivated, and it's very dangerous because the thing is completely diverted. You don't look at it as a real thing. Now, not saying that because of this we don't need human rights and developing of human rights and impunity, etc. But when I'm looking at it, those 60 years, my hope is very limited. I agree absolutely with you, Daniel, and I always say it, and with you, Irvin, we are not above the law. Israel is not above the law. What happened in Hebron a few days ago was condemned by Israeli society and will be condemned by everyone. But, as you say, we are not treated as all the other nations. By the way, let's say, take your case, that you were asked to be on this committee. And let's say that the situation will be different. Let's say that, yes, they would go to Sderot. I think that such a thing will help Israel to look at it in an objective way. For example, our decision about defense. that we were sitting together in the committee. Israel did not want to go to The Hague, to the ICJ, because the question that was performed to the General Assembly was so one-sided, did not even speak about the terror in Israel, so we said, that's it. We know from the beginning what is going to be the result. But if it would be differently, it would be more objectively, would we go? I don't know. I can't tell you today that we absolutely will do it, but it will help, I think, to come to a conclusion. One more thing that I want to tell you is thing that I don't know why, but it was passing like this. You remember the case of Al-Dura. Al-Dura was the father and the son that were in the Gaza point, that they were like sitting like this, and it was pinpointed that the Israelis shoot on them, and it was terrible. I was sitting a week ago in Paris, watching a movie that Mr. Krasanti, that is like you about Ahmadinejad, he's going all over the world about it, and showed how this thing was framed to the beginning to the end. But we don't hear how did it come out. He wrote an article in the French journalism saying that the television number 2 in France did know that this was framed and published it afterward. And he was sued, and he wanted to be sued because of it. I'm bringing him now to Israel to lecture about it. But the Israeli officer, 2 days afterward, came up and apologized for what we did. So, well, you can't, things like this are going to happen, of course. But this shows like how we are running into politics, and it's very, very, very difficult to fight it. And here we come, of course, to I heard now, by the way, that Syria is financing a universal jurisdiction against Israeli officers. So, we come to the money, we come to those points. The thing is that we have to do is to explain that Israel has to bring up more the position, what's happening, etc. And I think that this may be help, but about this question we are talking already, I think, since the State of Israel was born, and it doesn't happen. So this is my point that I want to just fast say about this thing, and that's it. Thank you.
I have to admit I am exhausted. I'm exhausted physically, I'm exhausted mentally. I see some other exhausted people. No, I'm not saying it's the end. I'm just saying... I almost was going to say I'm depressed, because there's so much bad news. The hopes of 60 years have been so much violated. And Erwin Kotler's presentation is certainly the type of critical, all of the presentations, both last night and today, this panel, at least provided, and this is the antidote to the depression and the exhaustion. Our goal when Avi and I sat down a year ago about it and said we should really have a public discussion, 60 years, was to have informed, critical public debate. And I'll speak for myself and say that every person who spoke last night and today, and Erwin who spoke twice, certainly, in my view, accomplished that goal. I don't expect that we're going to exhaust it in the next 10 minutes. And I see Anne's ready to go. I'll say a few more words at the end about where we go from here, including tomorrow's meeting at 10 o'clock for the participants in the program. But I'll open it up now for discussion. I was hoping everyone would say we're too tired. Anne, 1, 2, 3, 4. Go ahead, Anne.
Okay,
Anne, Shlomo, and Yafa, and then Jordan. And then we're going to quit, people. And then the panel, of course.
I got a press release about 10 minutes ago from the Office of the High Commissioner for Human Rights in Geneva. The press conference, it goes like this. High Commissioner is asked, does the draft Durban document, should the paragraphs on Israel go out, those are the ones that say genocide, etc., to persuade Israel to come? Her answer was, whoever your country and whatever your point of view, you have to be present and participate. She was asked, did Israel's blockade of the of the Gaza amount to genocide? She answered, it's up to the court to examine a case on a case-by-case basis whether genocide has occurred. She's concerned about Israel's violations of the right to life, given that more than 500 Palestinians and 11 Israelis have been killed this year. Meaning, obviously, that she's inferring that, of course, there is genocide. Then she's asked, this is the last one, quote, what is the High Commissioner's Office of the High Commissioner's collaboration with the International Criminal Court on Darfur? And she answers, the Office of the High Commissioner has set up a commission of inquiry which finds no evidence of genocidal policy. So, apropos of Irwin's remarks on genocide, today's High Commissioner for Human Rights, appointed, taking office only 3 months ago, has now used the opportunity of the anniversary of the Genocide Convention to suggest Israel's guilty of genocide, that it should come to discuss how much genocide there is or isn't at the Durban conference, and that that's not true of the ethnic conflict in Darfur. So I think
Where's the bad news here?
the point is that, you know, it's in some respects, I think we have to deny this institution credibility as a group. I mean, and our failure to understand these opportunities, I mean, of participating in the United Nations as a forward, well, the point is it's an opportunity to deny it credibility, and I don't think we can afford to do that. But I just want to bring you one other thing. And that is this whole issue of security versus human rights. I think the reason we get it wrong, and I think the Israeli Supreme Court got it wrong, is because they counterpose security to human rights. And it's the same as the UN does, you know, protecting human rights while countering terrorism. We have to end this way of describing the situation. Security is about human beings protecting human rights. It's not about government on one side and human beings on the other side. And we, human rights lawyers, fall into this trap over and over again. And we have to end it, or else nobody else is going to get it. That's what when Daniel said to human rights advocates, how come you have human rights experts, but you don't have anybody from military experts or the police, is because there's anti-human rights. And that's our fault in part for thinking that the military and that the police are somehow not protecting our human rights.
And I'm going to try to ask the people on the panel to divide it up into two sections. I think the legitimacy issue is extremely important. I know we're very short on time. Ruth addressed it, or semi-addressed it, Erwin, anybody else, and then after that the issue of the not just the way in which those two issues are juxtaposed, but I would suggest the term human security was invented by academics and others to justify that juxtaposition. And I think that's a real problem. But the term human security is a Canadian Office of Human Security, which says that there's something there that somehow merges those two issues together and blurs the distinction that Anne made.
As opposed to mere national security,
which is bad.
Which involves mere sovereigns, and therefore is not.
That's right. That's right. It further dissects those issues. Legitimacy.
But I very much agree that in any conversation in American politics, certainly human rights is Trump, and therefore opportunity
Jessica,
is a way of reframing the conversation is very important.
All right. Since the time is short, we're going to collect all four questions. Then everybody will have a chance to respond. Shlomo. Shlomo Slonim, Professor Shlomo Slonim.
Mrs. Montell mentioned that the Israeli Supreme Court handed down its decision a few days before the ICJ handed down its decision in the case of the wall. I'd like to point out that the International Court did not hand down any decision. It was an advisory opinion, and it is just that, advisory and an opinion. And it has no binding force whatsoever. And the fact of the matter is, as Judge Lauterpacht said in the Southwest Africa cases that he was adjudicating then on the advisory opinion, that an advisory opinion is just one opinion, and only an accumulation of advisory opinions might have some moral force. But we don't have to take that, and the Israeli Supreme Court also gave it the respect which was far beyond what it deserves. It is just the opinion, not even considering whether there was prejudice or whether some of the people should have disqualified themselves. It is just an advisory opinion as such. And this is important also with regard to other matters. I see that when the question of Israel's status in Jerusalem comes up, it is as if we have to take into account that there are those who maintain that Israel does not have a watertight argument under international law with its rights in Jerusalem. We do have such an argument, and I have presented it elsewhere. But the fact of the matter is that we have to recognize what advisory opinions are and what the opinions of others are on questions of international law, and treat them as their opinions.
Mr. Zillerschatz?
Well, with the audience permission and the participants, with the audience permission, I don't like to stand here. It's like I'm of the university. They're working reflections, but anyway, that's why I was sitting for 3.5 years and fighting for the faculty from this point of the room. So, okay, anyway, I will take this opportunity, and I apologize for the audience and for the participants for not being academic with your permission. And I would talk to my very beloved, good, admired friend, Erwin Kotler. Erwin, it's exactly 60 years to the Universal Declaration and the Genocide Convention, and exactly 20 years to the day I first met you here at Bar-Ilan University. I was still a young academic, and you were a youngest, and a little bit more mature scholar. And if I remember, and it was a very meaningful event for me, meeting with you and meeting Ariela and meeting Adassa Benito, and was exactly 1988, it's exactly 20 years from today. And since that was so, interesting on myself, I really remember every word that was going on at that point. And we were sitting in not such an elegant hall because it was not in existence in Bar-Ilan. And we were talking exactly the same words that we're talking today. And to a certain way, I was really listening to you, listening, meaning closing my eyes and hearing your voice. And I actually say to the certain point that all of the people that participated in really are part of quite a tragedy. Because like the Genocide Convention and the Universal Declaration were really an outcome of the Holocaust. And it was really an outcome that came out after the horrible things that happened to the Jewish people. And we find ourselves today a scapegoat and really a korban of this same system, which is really getting back to us, and we have to defend ourselves for something that we are fighting really to bring to the world, that Sarada to bring to the world. And I'm thinking, we're studying and we're making conferences and we're meeting, and exceptional people like you, like Irit, like Anne, and all my friends here, and Gerald, that are really raising the voice and exposing this problem. But actually, to a certain point, if I take these 20 years ago, we're not at a better point than we were 20 years ago. And the situation is not easy for me as a person. And I really want to ask you, please, and I said, and I really said before, I gave my academic share before. It's not an academic question. It's a Jewish, sincere concern. Seeing you as a leader of Jewish people in general, if you really believe that could be and we should believe that the system in a certain way can really benefit us, the state, and the Jewish people, and really למלא את המטרה, to really get the point that it was really made for. Please excuse me for being a little bit emotional and personal, but this is really what bothers me very, very highly. Thank you.
Well, we have to choose, but I will go with this one. This is actually a question specifically from Ms. Montell, and it relates to the Emergency Organization's database, and we're asking about fatalities. In that database, you classify Palestinian fatalities into combatants and non-combatants. In regards to the classifications, the organization has stated that those classifications are the result of an independent investigation of every person killed, which includes field research, interviewing any eyewitnesses to the killing, cross-checking our information with statements by the Israeli military and reports from the press, and corresponding with the military about individual cases. However, for example, on March 3rd, 2008, mere hours after a week-long intense Israeli assault on the Gaza Strip, your organization released a press release that stated at least 54 of 106 Palestinian fatalities in that conflict did not take part in the hostilities.